So a particularly serious crime for asylum is any aggravated felony. And for withholding, it's any to bar withholding, it's any aggravated felony where they've spent at least 5 years in prison. That's a pretty high bar. I mean, most people don't spend 5 years in prison.
Yeah.
So matter of NAM says, yes, that's what the statute says. But, anything can be a particularly serious crime. It's this totality of the circumstance, fact-based analysis. Is a particular serious. That's a dangerous place to be in. But matter of NAM makes quite clear, as does its subsequent precedent, that in order to get to the facts and be, seeing and withholding's mandatory, remember, there's no discretion. In order to get to the facts and determine if something's particularly serious, the first element the IJ and DHS must get over is that it must be the crime must be of the type and nature to be particularly serious. If it's not, you don't get to the facts. You don't do any more analysis on the particularly serious crime. So if an individual, for example, is convicted of simple assault and are you there?
Go ahead out here.
Sorry. So if an individual is convicted of only simple assault and in actuality they murdered someone, to use an extreme example, that crime will never be a particularly serious crime because they were convicted only of simple assault. It's kind of like a mini categorical approach. That's what matter of NAM says. And in Annor v. Garland, the BIA or the IJ didn't do it and they got dinged. In this case, it was conspiracy to commit money laundering. And they kind of just jumped to the fact that it was a pretty rough conspiracy that swindled elderly people
Huh.
mostly out of like $4 million and sent it to Ghana, I want to say. So yeah, it was $6.2 million,
Oh
200
boy.
victims. It's bad. It's like a love, a romantic it's bad. It's bad stuff. But the person's convicted only of conspiracy to commit money laundering. 1956H, which by the way is a per se aggravated felony, but it didn't get the 5 years. He only got like 3.5. Not a per se withholding, particularly serious crime. The IJ and everyone, they wanted to look at the fact that there were 6.2 million at issue and say it's particularly serious. Maybe that's right, maybe that's wrong, but the amount of money at issue is not an element of a conspiracy to commit money
Yeah.
laundering. All that must be shown, as the Fourth Circuit says, is that it requires nothing more than an agreement to launder money. And that's not particularly serious. That's not within the type of crimes that are particularly serious. Money laundering, maybe. But there are so many different types of money laundering at sections 1956 and 1957. Conspiracy is so broad, just an agreement to launder money. That's it. So Mr. Annor dodged a huge bullet there. Doesn't mean he's going to win withholding, but it means that he's not barred from it, even though what he did is quite serious.